Okay, thank you very much, participants, for today's training of trainers workshop on transitional justice in South Sudan. This training of trainers is supported by the government of the Netherlands, the Peace Building Fund, UNDP, and the Global Survivor Fund, in collaboration with the Rights for Peace and the Center for Inclusive Governance, Peace and Justice. Transitional justice remain key, and this training of trainers is aimed at empowering civil society leaders, policymakers, and survivors to engage in the transitional justice processes. And the aim is to equip them with the knowledge and the skills to be able to carry out awareness raising and outreach programs that will inform the next stage of the transitional justice processes, which entails truth-telling, reconciliation healing, and also the reparations program for South Sudan. Thank you all for coming for this training of trainers. So we are going to be looking at what is transitional justice. Transitional justice are judicial and non-judicial measures available to address massive human rights abuses of the past. Transitional justice includes prosecution, truth-seeking, reconciliation efforts, institutional reforms, reparations measures such as restitution, compensation, rehabilitation, symbolic measures, including public apologies or memorials. In other words, transitional justice are what we call the new beginnings from a violent conflict to a peaceful future through these processes. Why is transitional justice important? Transitional justice offers acknowledgement and dignity to victims and provide opportunities to hold those responsible to account. It can also offer opportunities for reconciliation and healing. As you are all aware, following the 2013 violent conflict in South Sudan, the region through IGAD and also international partners started the mediation efforts that led to the signing of the peace agreement in 2018, the revitalized agreement on the resolution of the conflict in the Republic of South Sudan. Through the creation of the high-level revitalization forum, IGAD mediated the peace talks in Addis Ababa. All parties to the conflict participated in the peace negotiations. And this, in September 2018, the revitalized agreement on the resolution of the conflict in the Republic of the South Sudan was signed. And this agreement has 8 thematic chapters, and key to this training of trainers is Chapter 5 on the transitional justice mechanisms in South Sudan. So this is one of the key thematic chapters of the peace agreement. Chapter 5 of the peace agreement provides for the establishment of 3 important mechanisms or institutions of the transitional justice. They are the Commission on Truth, Healing and Reconciliation, which is referred to as the CTRH, the Hybrid Court for South Sudan, and the Compensation and Reparations Authority, referred to as the CRA. Consultations with the public should take place to establish these mechanisms. The RT-GONU has carried out these consultations through the Ministry of Justice and Constitutional Affairs, and the Ministry of Justice and Constitutional Affairs established the technical committee that carried out these public consultations throughout the country. And survivors, particularly of sexual violence in conflict, were consulted and they shared their views. These views that were collected are very important in the design of the legislation that establishes these 3 mechanisms, and particularly the CTRH and the CRA. The African Union has a special mandate to support the government in the establishment of these three mechanisms, with a more focus on the hybrid court, focusing on the legislation for the hybrid court and also a memorandum that operationalizes it. Let's look at the Commission for Truth, Healing and Reconciliation Act of 2004 in details. In 2022, the technical committee established by the Ministry of Justice, in accordance to Chapter 5 of this peace agreement, went to all the states and collected the views of the citizens. A national transitional justice conference was organized by the Ministry of Justice in May 2023 with the support of UNDP and other partners. The CTRH bill was drafted in 2023 and adopted by the Transitional National Legislative Assembly on September 3rd, 2024. The purposes of the CTRH Act is to establish the Commission on Truth, Reconciliation and Healing. The adoption of the CTRH Act marks a significant step in emphasizing the rights of victims in South Sudan. Let's look at the hybrid court for South Sudan in details also. Although the RACCES, which is a peace agreement, set out three mechanisms, the hybrid court is yet to be established. The RACCES outlined that the hybrid court shall be independent. The court shall be established by the African Union Commission in collaboration with the government of South Sudan. And the purpose of the hybrid court is to investigate and, where necessary, prosecute individuals bearing responsibility for violations of international law and or applicable laws of South Sudan. The African Union shall develop guidelines and regulations for the establishment of the hybrid court. And the African Union shall nominate the judges, prosecutors, investigators, defense counsel, and the registrar of the court. To date, the African Union had submitted the draft statute and also a draft MOU to the Ministry of Justice. However, with the revitalized peace agreement, not much has been done, and currently the government has not started the processes for the establishment of this hybrid court for South Sudan. The Compensation and Reparations Authority Act 2024 in details. The Compensation and Reparations Authority Act was signed by the President on 11th of November 2024. The purposes of the Act is to administer a compensation and reparations fund to support the rights of victims impacted by the conflict and also gross human rights violations. The Act grants the CRA the power to receive applications from victims, including natural and legal persons referred by the Commission, and to make the necessary compensation and reparations. The CRA is to give reparations in terms of material and financial support to the victims. The Act also provides measures for reparations, which include material support, public apology, and also recognition of the victims. The Commission for Truth, Healing and Reconciliation. How will the commission be established? And this is a question that many citizens and survivors ask. According to Section 6 of the Act, the commission will be established and shall be impartial and independent. And it will not be connected to the interests of the government. The commission will last for 6 years from when the Act enters into law and can be extended once by the president. It can establish special committees that is based on Section 34. And these specialized committees in other truth commissions have included the Human Rights Committee, Reparations Committee, Gender Committee, and others include research and documentation committees. What is the mandate of this commission or the CTRH? The CTRH has a specific mandate to address the legacies of past violations and conflict. And for this matter, they have to inquire and also investigate human rights violations, which are gross, abuses, breaches of the law, and abuses of power by authorities. The CTRH can recommend processes for the full enjoyment by victims of their rights to remedy, measures to reparations, and compensation. And this is found in Section 7 of the CTRH Act. Who will sit on the commission and where will the commission be located? It's important to note that this commission is very independent and commissioners shall be of high moral character and they shall be impartial in their deliberations. They must represent a diverse background and perspectives. It's important that women are part of the commission, and under this law, it emphasizes the affirmative action of 35% for women, and this is under Section 11. The commission cannot have a commissioner who committed a criminal act or is being corrupt. A commissioner who violated human rights or conflict-related sexual violence or gender-based violence. So anyone who committed these above crimes and others will not be appointed to be a commissioner for the CTRH purposes. The law provides for 7 commissioners to be appointed. And out of these 7, 4 are from South Sudan and 3 are from the African continent, any country from the African continent. At least 3 must be women, and this is under Section 9. And from these 3, 2 shall be from South Sudan out of the 4, and at least 1 will be from the African continent. The CTRH will have a secretariat. Its seat shall be in Juba, but it will also have offices in all subnational or state level and the administrative areas. How will the commissioners be appointed? To ensure the commission is independent, a selection panel will select the South Sudanese commissioners. The panel will be represented by 1 representative of civil society, academia, eminent person, 1 person from persons with disability, 2 religious leaders, 1 person from the victims advocacy group, 1 woman representative, and 1 youth representative. It's important to note that the South Sudan Network of Survivors, which is called as the SANS, has recommended one survivor representative to be in the panel. The civil society, the women groups, the faith-based have also nominated their representatives to the panel. The shortlisted names shall be published in the media, and the public will have 7 days to comment. The panel will publicly release the final 4 names, which will be submitted to the parliament for vetting and then to the executive for their appointment. What are the powers of the commission? The powers of the commission or their functions include summoning any individual to give testimony or to produce documents, grant amnesty according to specific criteria, excluding amnesty for crimes of international nature. This means that violations of international law and also international human rights law will not be given the amnesty. So anyone who commits international crimes will not be eligible for amnesty. Inquire into reports on the conflict. Protect victims and witnesses with special measures. For example, holding private hearings. And that means also taking into consideration the survivor-centered approach in their deliberations. Receive applications from victims and record their experiences. Determine and administer interim reparations for cases of threat or emergencies. Also, these interim reparations based on the law include psychosocial support and medical rehabilitation for victims. Identify perpetrators of crimes or human rights violations. Lead efforts to local and national reconciliation and healing. Develop standard operating or procedures for transitional justice mechanisms. And then make efforts to inform the public. And finally, to develop and issue a final report of their work. How will truth-telling work? In order to gather a complete narrative, the Commission shall order and investigate documents relevant to the cause of the conflict, the impact, and also the nature. It will also record the experiences of victims, including the experiences of children and women. Take statements, summon people to give testimonies, and also statements. Section 8. The Commission shall ensure the integration of psychosocial support services to address consequences of truth-telling for victims, witnesses, perpetrators, commissioners, and staff. That's under Section 36. Many people will ask, can the Commission grant amnesty in exchange for truth-telling? The Commission may decide to grant amnesty to persons who truthfully confess and present evidence, with the exception of any act or omission, crimes that amount to genocide, crimes against humanity, and war crimes. And as I stated, crimes that are violating international humanitarian law, that have caused war crimes, And then crimes against humanity, which include sexual violence against women in conflict, cannot be treated and accepted for amnesty. In granting amnesty, the Commission will consider the motive, the context in which the act or crime took place, whether the act was committed in response to an order. What is the role of the victims? It's important to note that for any transitional justice process to move forward, the victim-centered approach is important, and the Commission shall carry out public education and awareness raising in order to inform and engage with the public and ask for feedback. This is under Section 8 of the Act. Survivors of CSRV have the right to be informed about the process and opportunities to apply for reparations or to make statements. Survivors have emphasized the need for security measures in order to enable participation, and trust in the process. It's also important to note that the civic space is very important for survivors to participate and also for the public to participate in the truth-telling processes. The CTRH can use different methods for public participation, including statement taking, public hearing sessions, closed hearing sessions, interviews, focus group discussions, community visits, engagements, and also media or radio programs. What can the Commission do to protect victims? The Commission shall implement measures to protect victims and witnesses, including protection of identity during witnesses or testimonies, identifying perpetrators of violations of human rights and crimes. These measures should be developed and implemented with the input of survivors with their needs in mind and their priorities. Survivors have advocated that protection measures should include well-paid security, options for private testimony, and other arrangements, staff that is trauma-trained, temporary safe houses. How will the Commission provide interim reparations? The Commission shall determine and administer interim compensation if there are cases of health threat or emergencies, and also looking at the psychosocial elements and trauma for victims. Interim reparations are important measures in ensuring that survivors have access to support without having to wait until the final report of the Commission. Recommendations should be made on what qualities as an emergency through input and consultations with survivors and other community members. What are the roles of religious, traditional, and cultural justice mechanisms? Under the CTRH and under the RXS, traditional leaders play a big role in the CTRH processes. Also in the South Sudan context, traditional leaders play an important role in fostering healing, reconciliation, and maintaining order at the level of the communities. The Commission shall adopt practices for truth, reconciliation, and healing from religious, traditional, and customary justice mechanisms in South Sudan, South Sudanese traditions, from African countries and elsewhere in the world. Chapter 5 of the RXS states that the CTRH shall draw on existing traditional practices, processes, and mechanisms where necessary. The practice should facilitate the full enjoyment by victims of right to remedy. The standard operating procedure to be developed by the CTRH should include input from the victims and CSRV survivors, in particular to address issues of confidentiality, safety, dignity, and stigma. The CTRH commissioners at the end will write their final report and also make recommendations for institutional reforms and for implementation by the government. The Commission shall provide quarterly update reports to the government. It shall present quarterly reports to the Assembly for deliberations and adoption. The Commission will issue a final comprehensive report at the end of its work as of Section 41. The government will develop a program to implement recommendations and proposals from the Commission. The Ministry of Justice and Constitutional Affairs and the South Sudan Human Rights Commission will monitor the implementation of the recommendations. A transitional justice policy will be formulated by the Commission for implementation. The public has the right to be informed on the status and information related to the Commission. The public has the right to participate and also to share their views with the Commission on the CTRH processes and other transitional justice mechanisms. Compensation and Reparations Authority. What is the structure of the CRA, or the Compensation and the Reparations Authority? The authority is made up of a board and a secretariat. There shall be 17 members of the board of the CRA, and women will make at least 35%. This composition is categorized as 7 representatives from the parties in the Artigono, and that means all the parties who are in the Artigono and who are signatories of the RXS, 2 civil society organizations or representatives, 1 representative from women groups, 2 representing faith-based, 3 representing the business community, 1 representing the youth, 1 representing traditional leaders, 1 representing persons with disabilities. The Secretariat shall provide administration and shall be headed by an executive director appointed by the board. The authority shall administer the Compensation and Reparations Fund. What are the powers of the board? Powers and functions of the board include develop rules and procedures and policies for the compensation and reparations, approve the CRA board budget, approve compensation and reparations. This includes also the interim reparations, monitor and manage the compensation and reparations fund, approve the appointment of the Secretariat Executive Director and staff, as well as the manager of the funds. The Secretariat shall be the administrative arm of the CRA and shall include staff with technical skills. How will the authority encourage participation and provide information? The authority shall establish and ensure transparency in oversight and management of the CRA operations, encourage and promote awareness and involvement of victims and community-based organizations, civil society, faith organizations, and the public. Facilitate media outreach and other public education and engagement activities. Encourage the participation of vulnerable persons. Ensure that information on remedies for human rights violations is available and accessible in accordance with the Commission. Make recommendations to the Commission for personal reparations when awarding of communal reparations is appropriate. How will the CRA determine and grant compensation and reparations? The authority shall receive applications from victims, both natural and legal persons, including referrals from the CTRH, make necessary compensation and reparations, verify information and receive evidence to determine compensation and reparations, define and classify the victims to determine eligibility, make recommendations to the Commission for personal reparations where communal reparations are not appropriate. The authority shall implement all referrals for compensation and reparations made by the CTRH, award communal reparations following the public release of its report. The Commission shall also award individual reparations to victims, including victims of conflict-related sexual violence, and also for children born out of rape. How will the authority support the healing process? The authority shall establish victim support and memorial centers at the state and community levels to provide a continuous healing processes. Commemorations and tribute must be sensitive to survivors and witnesses and involve survivors in the decision-making processes. What reparations measures are available? The Act provides for reparations measures under Section 8. And in Section 8, the CRA outlines the following as measures. 1, verification of facts and public disclosure of the truth that does not cause further harm. Inquiry into the whereabouts of disappeared persons and for the bodies of those killed, including assistance in their recovery. A public apology that recognizes facts and responsibility of perpetrators. Reaffirming the government's duty to ensure non-repetition of violence, including the structural and institutional reforms. The principle of no to violence. Again, commemorations and tribute to victims, inclusion of victims in the formulation of education curriculum that may include accounts of crimes, human rights, and violations and abuses. Any other measures to address the root causes of the violations. Victim support and memorialization centers at the state and community level. Thank you very much all for attending this training of trainers. And this program is very important, not only for the training of trainers, but also for more of the civic awareness and outreach programs around the transitional justice processes. Please read understand the transitional justice process in South Sudan, stand up and participate in the implementation, monitoring, and share your views in the design and also during the process of implementation of these two important mechanisms of the CTRH and CRA. Thank you all for listening, and we remain indebted to the government of the Kingdom of the Netherlands, the Peace Building Fund, the UNDP, Global Survivor Fund. At Right for Peace and CIGPJ, we remain available in building capacities and also networking and supporting the people of South Sudan to achieve the mandate of the transitional justice for sustainable peace and development. Thank you. Hello, Mariana and Solen.